Just a few words at the beginning regarding startup lawyers. We are working under this name for 12 years already, helping especially international startups with their setup in Germany, with the incorporation, with the first contracts they close with employees, with service providers, with registering of their trademark, with financing as well, public funding and private financing. We are a team that is much bigger already than on the picture. The picture is already, I think, 8 or 10 years old. We finally will have a session with the photographer next week to include Frido also, who will take over in a few minutes and who joined our team a year ago. Our law firm is, just to give a few words before, is quite international. I'm in Paris today, Frido is in Berlin. We are working, as I said already, with many international clients from all over the world, and have offices in Italy, in Milan, in Paris, and in Berlin, with a strong focus in Berlin. We try to have a fair pricing that really considers all the needs which startups have, to give package deals for the founder teams and for several standard tasks. We are young. I'm the oldest, with 45 years. We are very multilingual. We speak many languages, especially French, Italian, Spanish, even Japanese. We try to be very fast. We try to answer every email at least within a few hours, so then you're not waiting for days to proceed. We try to be very pragmatic, not to send you long emails with explanations, but really try to be hands-on and to get things moving. Try to keeping everything simple, and that's to find problems where maybe there are workarounds. And Frido sent other slides to make more publicity for us. We are working in these fields mentioned here on the slide. Yeah, that's a bit about our firm. We have been working for many clients from the start on who have grown up quickly, like Urban Sports Club, Delivery Hero, which we accompanied from the beginning on, Bubble, which you may know, a language learning app. These are like 5 of our first clients, which we are still working with, or most of them almost 10 years. In total, we have helped around 100 to 200 international startups to set up their business in Germany. So really experienced with all these bottlenecks that may pose problems to your incorporation in Germany as well. Yeah, that's about it. And then I hand over to Frido.
Hi, everyone. Nice to meet you all. Thank you for joining us today. I'm Frido. As Raphael mentioned, I'm a lawyer at the Startup Lawyers here in Berlin, in our Berlin office. I am advising clients on all things civil law related, and especially in the field of setting up companies, everything around corporate law. So very much the topic of today's session. And without further ado, I'd like to get started on today's theme, setting up a company in Germany. And the first question one may ask is it necessary? And that is a question, of course, for whether you are a team of founders in Germany that may not have yet a business, or if you've already got a business and you're planning to expand into Germany. There's of course various ways to do it, and there's other ways to do it than to create a German company. You may, for example, just go ahead from abroad, meaning that you can expand or conduct your business from outside wherever you're based, and you close your contracts either directly from there, so you sell from wherever you are, or you have resellers, dealers, representatives. That's coming with the obvious drawbacks being there always being a middleman involved in your business, or you facing logistical problems by transporting goods into Germany. There may be taxation issues, and also from experience, we can say that local businesses will always prefer partners with a company based in Germany rather than having a business partner in a foreign location. For example, in case things go sour and there's a legal proceedings, German businesses don't like to go abroad and sue there. The other option outside of setting up a company would be then to have a branch office for your business abroad, which is on paper a fairly simple process. You just simply register with the commercial registry a branch office in Germany. That is comes with more of a bureaucratic headache than it sounds, however. And I think somebody earlier mentioned that the bureaucracy in Germany can be hell. This is, I think, a good example because you're not just setting up a branch office, you also have to feed all the information of your mother company abroad into the commercial registry and keep it up to date. That means that all information regarding shareholders, managing directors, etc., have to be up to date in the German commercial registry as well. So every time there's a change in the mother company, you will then have to go to a notary's office and change the entry in the German commercial registry as well. And also to do the comparison here to a German entity or German company, it is not a limited liability. So your branch office will ultimately be liable together with your mother company in wherever your business is based, meaning that if your business in Germany does not go well or you get sued here, it's all related to your mother company. I can name a few more things why branch offices are often tricky, but to get to the point of today's session, there's the last option, and that is setting up your own company in Germany. And that can be many legal forms, but we'll get to that, often be a limited liability company. Now, further reasons why you would want your own company in Germany is it's significantly makes it easier to hire staff in Germany, although it's not always necessary. It's recommended to do it through a German entity if you want to employ people in Germany. It can serve as a sponsor for visa or residency, meaning that if you're not an EU resident, for example, and you need a residence permit, this can be done, for example, through your own company if it employs you as managing director, condition to further residential law requirements, of course. Lastly, setting up your own company can prevent the pitfalls of the so-called unlimited partnership. Now, without wanting to go too much into detail here, it's to describe it in short, it's if you don't form a legal entity in Germany, but you still work together with someone and you pursue a business purpose for a longer period of time, especially, it's implicitly you are founding a so-called Gesellschaft bürgerlichen Rechts, which is this unlimited partnership. And that is sort of a legal entity, which can often lead to conflict when later on people who have worked for this common purpose and there's no legal umbrella company demand a share in the profits, etc. So it is better to set up a company to clearly divide tasks and powers straight away. Exactly. And that brings us to the next question. When you do want to set up your company in Germany, there's obviously a lot of legal forms, one being this limited partnership that I just mentioned. But there's here, just to name a few, also the Aktiengesellschaft, which is a stock traded company. There's the Einzelunternehmer, being a social entrepreneur, single entrepreneur. There's a Kommanditgesellschaft, offene Handelsgesellschaft, and then the unlimited partnership. And then there's the two, I think by far, it's fair to say, most popular forms for companies, which are the Gesellschaft beschränkter Haftung mit beschränkter Haftung GmbH and the Unternehmergesellschaft, the UG, which are both limited liability companies. It's pretty fair to say that unless there's really specific requirements in your company, to start with at least, you will almost always resort to the GmbH or UG as the legal form for your company here. Just to name a few benefits, and I think these are the most striking ones, speaking for in favor of the limited liability company, that would be the market reputation, meaning that a GmbH in Germany has a very recognized standing. So does the UG, the sort of little sister of the GmbH. Both of these are will be entered into the commercial registry, where business partners of yours can draw all the necessary information, starting with managing director, share capital, as well as shareholders, the address of the company, etc. And that makes it very, very interesting for your business partners to conduct business with you, obviously, rather than you performing business either as just a social and private individual or as a group of people with a GmbH or UG. The business partner knows who they are doing business with and who, to use lawyer terms again, they can sue when things go sour. The next benefit of a limited liability company in Germany would be that, and I think it was mentioned earlier, VC funding or financing in general. Investors, from our experience especially, will require you to use one of these limited liability company forms, simply because to secure investor interests, for example, they will alter the articles of association. There will be certain mechanisms, without going too far into detail, but there, just to name a few, it's like vesting, for example, or the founder lockup to keep the founders of the company inside the company for a little bit longer. Investors often implement certain mechanisms, and that can be done a lot easier and a lot more flexible in the legal situation of a GmbH or UG in comparison to other limited liability companies, such as a stock traded company, which is a lot more restricted strictly by law. And last one would be, I guess, the most obvious reason why a limited liability company is beneficial for you, because it has limited liability, meaning that your business abroad or you as shareholder in general will not be liable for is only liable with its share capital. Okay, and next. In Germany is, when do I incorporate my company? And that is generally up to you to decide. You can freely choose the point in time when you will set up your company, but there's good reasons from our point of view that speak for an early incorporation rather than a later one. One being that with especially the start of your operative business, you will sign a lot of contracts, be it for loans or service contracts, etc. And it's always better to have the company, due to its limited liability, be the contractual partner of these contracts rather than to sign them as a private individual first and having to sign them over later. Next point being that a early incorporation allows for you to early on transfer all relevant rights to the company and to avoid bureaucracy and disputes between shareholders or other freelancers working for the company later on. This falls a little bit into what I touched upon earlier, this limited partnership problem, where if you work together for one business purpose for too long, and everybody contributes, but there is no real company that everything the contributions go to, it is very unclear later on who the rights, for example, to trademarks belong to, that being your name or the logo, especially if you register them as a private person early on. And lastly, and this is more of a practical advice, it can help to structure your tasks and responsibilities in when you incorporate early on, because through shareholder agreements and articles of association, and by naming your managing director and distributing the shares, you get a better idea of who is in charge of what in your company and who will take over which tasks in the future. Yes, and that brings us to the next point, the basic structures of companies in Germany. And with that, I would like to hand over to my colleague, Raphael, again. Thank you.
Thanks, Frido. Okay. Thanks. Could you pass on to the next slide? Sorry. Who plays a role in a GmbH or GM or UG, a limited, any sort of limited company in Germany? On the one hand, we have the shareholders. The shareholders are those who own the company, who own the shares in the company. I guess this will be very clear to most of you, but as there are participants of every stage, I think of incorporation, it's good to stress that, and we need this information also for the further explanations I'll get back to later. A shareholder of a company can be a natural person, so like you and me, every person, which can be based in Germany or abroad. You don't need a residence permit or a residence address in Germany to create a company here as a shareholder or to buy shares in a German company. It can also be a juristic person, so a foreign entity or a German entity, of course, like a French SAS, SAL, or any limited from the UK or the US can buy shares or create companies in Germany with which are owned by these local or foreign entities. In case the company is owned by legal entities from abroad, we need a so-called certificate of existence and representation. What is in most cases, it depends which country this legal entity comes from, is an excerpt from the commercial register showing exactly who is allowed to represent the company, who owns the company, which will buy the shares and which will be able to sign the documents in front of the German notary on the day the company is created. So we have the shareholders who own the company, and then we have the management, the Geschäftsführung in German, who is responsible for the daily decisions which are made in the company, who is representing the company, who is signing contracts on behalf of the company, who is employing people, and so on. Only very important decisions are made by the shareholders. The daily decisions are made by the management. The managing director can only be a natural person in Germany. This is different in other countries. But the management of a company, the Geschäftsführer or the Geschäftsführer, because you can have many Geschäftsführer if the company grows, must be a natural person, so someone alive like you and me. And yeah, I think the other things that I mentioned here, especially the last thing, sometimes problematic in terms of labor law. If managing director is no majority shareholder, this refers to a problem we have with social insurance in case that the managing director is not owning a major part of the shares, we say at least 50%. He will be regarded as an employee who is subject also to the obligation to pay social insurances, or the company has to pay social insurances for the job he's doing, the work he's doing. The standard set up for a company in Germany, for a GmbH or UG. Everything that we are talking about here refers to the UG and the GmbH, if not expressively mentioned that we are referring to one of these entities, because the UG is just a small form of the GmbH, but all the regulations we have in the GmbH law, the GmbH-Gesetz in Germany, also refer to the UG, with just a very, very minor exceptions that are not very important at this stage. We will get back to that later. So normally the setup is is like here, that the GmbH is owned by 1, 2, or in this case 3 shareholders. Here we have 2 founders as natural, who have invested or created the company with them as a natural person, and 1 foreign entity, an incorporation here, which holds 30% of the shares. There is no limit in the amount or the number of shareholders. It can be actually every share has to have a value of at least €1. So depending on the share capital, if the share capital is 25,000 euros, what is standard for the German GmbH, there could be theoretically up to 25,000 shareholders, which is obviously not very, doesn't make much sense, because decisions would take very long and would be very unusual. Then we go here for the so-called advanced setup of a GmbH or UG. And what you see here on the right is something which is done mainly for tax reason or for taxation. In case the company, as in the previous example, is owned personally or directly by the founders or the mother company, it would mean that when money, in case of an exit, for example, is taken out of the company by the founders, would lead to high taxation. What is not the case with this advanced setup, because here, in case of an exit, for example, the money can be reinvested into further startups. Some of you may be serial entrepreneurs who would invest their money in their next venture or in a friend's company. And this can be done in case the shares in the company are not held by you personal, but by a so-called holding UG or personal UG. In this example, the details should be discussed in case you decide creating a company, but you should definitely keep that in mind, asking your lawyer or us, in case you work with us, to consider this and to discuss this before creating your company, because this actually can not really be done at a later stage. It's possible to do it, but you are blocked from this taxation benefits for a period of 7 years, to make it very simple. Okay, I would leave the rest here. Yes. Then we have, as we said, we want to keep it easy and simple to make your start in Berlin easy to understand. We have here an overview of the timeline. This is how it works. The beginning, and especially in case you are creating your company as a daughter company of a foreign entity, we need quite a lot of documents, which includes the certificate of incorporation, excerpt from the Foreign Commercial Register, several translations in many cases, notarized signatures from a notary in your home country. This depends, because there are treaties, contracts, agreements between Germany and several countries, which make, in some cases, it's very easy. In some other cases, it's a lot of documents, also for anti-money laundering purposes, which have to be gathered and reviewed and first checked by the notary before we can start the process. So this is, in many cases, the thing where you really need guidance by a good notary or by a firm like ours who's experienced to that, and where which sometimes slows down the process in case there are problems that these documents can be provided in time. As soon as we have all these documents here and the notary has agreed that he can start the company incorporation process with these documents, we draft the articles of association, and which takes not much time in most cases. Then this can be done in a few days. Then you do the incorporation in front of the notary, where you in general have to be present as representative or the representative of the shareholder, or the representatives, if there are several shareholders, have to be present, which can also be avoided by power of attorneys. Then you after the notary meeting, you have to set up a bank account, pay in the share capital, which in some cases also is a bottleneck which slows down the process in case you come from a country which is on a blacklist of the German banks. In case this is not the case and you are, for example, citizen of the European Union, there are online banks like N26, Revolut, or Penta especially, or Holvi, which work quite easy and where you can get an account within a few hours. You then pay in the share capital, in which needs to be with a UG just €1. For GmbH 25,000 euros, of which 50% of 12,500 have to be paid in at the beginning. You send a proof or the notification that you have paid in the share capital to the notary. The notary files the company registration to the trade court, to the Handelsregister, and within a week or two, your company is fully registered. In between these two last steps, where the company has the commercial register has been notified by the notary already, there is already some kind of limitation of liability. You can already start your business, but the full registration takes around 2 weeks. The costs, very roughly, are around, for GmbH, 1,000 euro notary costs for the notary, for the incorporation, around 1,500, depending on the complexity of the articles of association, on the question whether or not you want to also install a vesting, which Frido already mentioned, to make sure or incentivize your founders to stay within your company. Same for VSOP or ESOP program, an employee and an option program to make your employees participate in the company at a later stage. Then you have costs around 150 or 200 euros for the commercial register. So the total costs for quite an standard setup are around 2,500 to 3,000 euros.